Hello everyone, my name is Ashley Hornsby and welcome to Chapter 46. I will be discussing court cases, procedures, and recent decisions. No federal government mandate exists that will entail school districts to deliver special programs for gifted students. Gifted education promoters essentially look to state governments to safeguard the importance of gifted students. And approximately 3/5 of the states have passed a statutory mandate requiring special instruction for the gifted, with the balance of the states choosing the permissive route. Approaches for resolving legal battles in gifted education can be in the form of casual considerations. They also can be in the form of state Supreme Court decisions. Defining the dispute at the negotiation level will be the best answer. Steps to resolve issues: negotiation, mediation, due process, administrative review, and the courts. Negotiation is the process of two or more individuals trying to reach an agreement, and I've provided examples below. So if the matter was in respect to a suitability of standards for admittance to a program, you would need to contact the person responsible for the exams. Another example is, if differences occur over a program a student was placed in, the conversation would need to be with the person accountable for assigning or for the program. When individuals cannot agree, the next step is to connect with the principal and possibly the superintendent and school board. Continuously make sure your facts are accurate when presenting the issue, and also retain records of all actions taken. Mediation is a process by which disputes are resolved in an informal manner, with a minimum of time, money, emotional, and psychological stress. 21 states have a mediation process that can be offered, and this process may be used if negotiation has not produced the anticipated results through the Board of Education level. Parents and educators can appeal to use mediation process either through the State Board of Education or any other state designated agency. If mediation is not obtainable, or if an arrangement cannot be grasped through mediation, then in 26 states, procedural due process may be employed. In states where the gifted are provided the similar privileges as the disabled, due process is frequently encompassed within special education law, as well as regulations and rules. The most mutual track is through the overall state due process practice for all students. I've provided examples below that can lead to a due process hearing: appropriate placement, appropriate programming, program eligibility, identification, compensation, and other issues. So to discuss issues in administrative review in courts, the appeal process varies from state to state. So usually appeals are made to the state superintendent of education. And then if the appeal to the state agency is not reasonable, the parents or school officials can choose to utilize state or federal courts. Factors to consider when taking the issue to state or federal courts are included below. So you really need to look at how much it will cost to hire an attorney, and if that attorney is knowledgeable of education law. You also need to consider that court cases are timely, emotionally draining, and could take years to make a ruling. Some examples I've provided for you of major conflicts that can often arise between parents and school districts: early admissions, issues with provision of programs, issues of racial balance in gifted programs, and the list goes on. So, I'd like to discuss some issues of early admissions. Numerous states carry statutes that stipulate that a child must be a certain age by a certain date, and so I've provided an example court case below. Wright versus Ector County Independent School District in 1993 case. In this case, it involved a parent seeking early admissions for her child. The county board had adopted a blanket policy, and the parent was denied the early admissions for her child, even after her claims were sent to the appellate court. Issues with provision of programs. A lot of parents choose to utilize the court system in order to make their school district offer gifted education programs. So in some court cases, the state may mandate a school district to provide gifted education programs, but if they do not, oftentimes parents' pleas will be ineffective. An example court case of Bennett versus New Rochelle School District of 1985 case involved little funds to support all gifted students. The district was sued by a parent claiming that the school district's actions violated state statutory and constitutional laws, as well as the Equal Protection Clause of the federal Constitution. The claims were rejected and appealed, and Bennett lost on the claims. Issues with racial balance in gifted programs. Some school districts place an importance on IQ tests, and in doing so, they ended up overlooking gifted minority students. So racial imbalance in gifted programs called for court desegregation orders to make school districts cultivate a diversity of actions for categorizing gifted admissions criteria. Such criteria would include teacher and parent recommendations, self-nominations, grades, and standardized and non-standardized assessments. An example court case has been provided below. Carnegie units are units that differ from state to state, and some states permit 7th and 8th grade students to register for courses designed for 9th through 12th grade students. But then these states will not allow the award for the appropriate units. And in 22 states that are authorized to grant Carnegie units, the issue of not awarding them still remains. Issues of transfer of students. So oftentimes parents will transfer a child to another district when the student's academic, intellectual, or talent needs are not being met by a public elementary or secondary school's gifted program. And in transferring, you may find difficulties. An example court case I've provided is Davis versus Regional Board of School Trustees 1987 case. The family was given a transfer through annexing the family farm to the property of the adjacent school district to only have the school board deny the petition. The trial court granted the request of the parents, and the appellate court upheld the decision of the trial. Issues of appropriate instruction. Oftentimes, parents are judgmental of the appropriateness of instruction provided in their child's gifted program, and this can cause stress and strain between the school district and the parents. One of the most important court cases that I can mention in this PowerPoint is an example of the district wanting to provide a service to gifted students and reserving 90 minutes each week to provide specialized instruction. This court case is the Continental School District versus Commonwealth Department of Education, 1988. The parents of a gifted student attending this program believed their child was not receiving adequate instruction. They requested the district to provide him with individualized instruction to meet his needs in a regular classroom. The district refused, stating that the program was the only economically feasible approach to fulfilling the state mandate to serve gifted students. The Pennsylvania Supreme Court ruled that individualized instruction need not maximize each gifted child's abilities. Rather, the district was to provide individualized, appropriate curriculum to its gifted children, but did not have to allocate additional resources. Issues of gifted and disabled. Parents of children who are gifted and disabled generally use the Federal Individuals with Disabilities Act as a basis for claims. This law is more protective and more supportive of children than a state's gifted education statute. When the facts of a case allow the federal statute to be joined with a state's gifted education law, the parents have a stronger legal outline to gain suitable teaching for their child. I've provided a court case below, Conrad Weiser Area School District versus Department of Education of 1992. In this case, the child had a high IQ and a great intellectual ability and should be able to qualify for special education services due to his learning disability. The district rejected the parent's plea for the special education instruction. The trial court stated that the child was entitled to special education services. The local school, however, did not provide the gifted services to him, even though he was identified as having superior intellectual ability. The parents moved the child to a private school. However, the school did not have a gifted program, and a new IEP was created, and a class just for the child was added for him to attend. The parents did not want the child to be alone because he would not have the advantages of interacting with other gifted students. Therefore, the parents requested a due process hearing to provide special education services at the school, and it went all the way to federal court where the judge ruled that the child was entitled to interpretive services. Issues with teacher certification. Teacher certification supplies legal refuge for gifted education teachers in times of personal bargain and serves as a defense against the hiring of untrained teachers for gifted education positions. In the example court case below, Johnson's versus Cassell, 1989, Johnson applied for a job that he was not awarded. Instead, the district chose a candidate that did not have graduate training, a certification, nor gifted education experience, whereas Johnson did. He sued the district in a local trial court. He lost and appealed the matter to the West Virginia Court of Appeals. The court ruled the action of the district, stating that it was arbitrary, and awarded Johnson the position. Issues with transportation. I provided an example court case below where the gifted student who attended a private school were not receiving transportation to and from the special services that they were receiving at a public school site. In addition to this, the department ruled against the district, citing a statute specific to special education, and because gifted students fell into special education category, private school gifted students would have to be bused to the public schools for instruction. Issues with tort liability. Any program that will allow for residents, field trips, and transportation to and from sites will often present chances for accidents. Case law illustrates the need for attentiveness in defending gifted children. An example court case below, Derringer versus Plain Township of 1985. In this case, the student was rewarded for her academic achievements and was given the privilege of bringing a television cart from storage to the classroom. As the child rolled the cart down the hall, the television unfortunately toppled upon her. Issues with fraud and misrepresentation. In this court case, O'Neill versus Marjorie Walter School for Gifted Children of 1985, the owner of a private elementary school advertised that teachers were certified in gifted education and indicated that the program was based on individualized instruction. So, in addition to this, several parents disagreed and took the proprietor to court. Unfortunately, this case has still not been settled. Issues with homeschooling. When parents are displeased with the education of their gifted child, they will seek suitable alternatives such as homeschooling. Homeschooling has yet to be involved in a due process hearing or a court case involving a gifted child. Nevertheless, the fact that an increasing number of gifted children are homeschooled, you can probably guess that some form of legal issue will occur. The National Association for Gifted Children states to educate all our children and allow America to compete in a global economy in all fields of human endeavor. The nation must provide an environment in which gifted and talented students, along with all of our children, can reach their full potential.